This is Agriculture Today, and I'm Shelby Varner with the K-State Radio Network. Beginning today's show is Roger McEowen, K-State law professor with knowledge on recent cases involving agriculture. Today's conversation includes a takings case, a bridge obstruction ruining crop, and the importance of a buy-sell agreement. Jenny Ifft, K-State Agriculture Policy Specialist, continues the show with history about agriculture policy and the Farm Bill. She talks about the farm financial crisis and freedom to farm. Concluding the show today is Brad White, Phillip Lancaster, and Bob Larson with the Beef Cattle Institute. On this segment of Ask the Experts, they converse about when to pull bulls out of breeding pens. That and more is coming up ahead on Agriculture Today. You're tuned in to Agriculture Today, and we start this Wednesday show with some information about agricultural law. And then to share some of his knowledge, we have K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
And Roger, something we wanted to talk about today was farmers having issues with the Missouri River flooding and causing damages to their fields.
Yeah, that's right, Shelby. From about 2007 to 2014, there were flooding problems in numerous years along that Missouri River corridor, basically all the way from St. Joseph, Missouri, up to Fargo, North Dakota. And anybody that drove Highway 29 or Interstate 29 during that period of time noted that there were a lot of farm fields that were flooded. The Missouri was out of its banks. There was a lot of damage in that corridor. And we've had litigation over that that's been going on for about a decade, and finally have, I think, a pretty good resolution of this for the farmers involved, and it looks like it'll be a final resolution. Of course, the U.S. Supreme Court would remain, but now we have the U.S. Court of Appeals for the Federal Circuit out of D.C. that has basically agreed with the trial court, Federal Claims Court, on a takings issue, but then expanded it a bit. And so there's going to be even more relief for these producers and landowners in that corridor than what the claims court had said.
And to my understanding, the flooding didn't just happen. The Corps of Engineers kind of created the issue, which is what made this a case.
Yeah, that really is a big part of what the case is, because the Corps had made changes to their master manual, which is what it's called, in 2004. And then some other changes after 2004 in their processes to basically re-engineer the Missouri River and establish what they said were more natural environments to facilitate species recovery of wildlife that uses the Missouri River. And those changes led to unprecedented releases from Gavin's Point Dam in South Dakota after heavy spring rains and snowmelt were already creating a high river level in 2011. Of course, the snowmelt and the heavy rains were out in Montana, and that was already filling the river up. Well, then the Corps added more water to that, and the claim was that that's what exacerbated the problems, made them worse. And had the Corps not done that, the problems, we may not have had the flooding, or definitely would not have had the flooding to the extent we did. And so the primary question was, is the Corps responsible for that? Was there some type of causal tie between what they did and the damage the farmers sustained up and down that Missouri River corridor? And the way you pitch this as a takings claim is that, well, this is a government agency, and the government can take my property if they want to. They're the big bad government. They can do that. But the Constitution says if the government takes your property, the government has to pay what the Constitution calls just compensation for it. And so this was pitched or couched as a takings case in the U.S. Court of Federal Claims, which is where all the takings cases go under the Tucker Act. And the Court of Federal Claims said, yes, there is a taking, but that the farmers could not receive compensation for crop damage and some of the property damage. But the government had taken what's called a flowage easement over their property. That has to be compensated for. The farmers appealed this and said, well, we should be compensated for our property loss and our crop revenue loss too. And the appellate court agreed with that. And so now it's going to go back to the lower court on remand to calculate those damages.
Even though it's affected things in the past, are they going to see compensation possibly for things moving forward as their land is still damaged?
Yeah, we had basically 44 landowners up and down that corridor that was selected as what we call bellwether plaintiffs to establish the Corps' liability. Now, what the court on remand has to determine is the extent of the damages, the property owners that are involved in this that should be compensated, and the value of lost crops and the future value of lost crops, because that land has been damaged for some time. It'll recover eventually, but the productivity of the land is much less now than it was prior to the flooding. Now, eventually that will come back. And so now you're going to have expert analysis, economists, soil agronomists, those types of things. And it's going to be very costly to the Corps, because the Corps is going to have to pay for all of this to determine what the damages are, and then they're going to have to compensate the farmer. So there's still quite a lengthy road to this, but the resolution of the taking issue is done, as far as I can tell. Now it comes down to the calculation of the actual damages and the parties that are entitled to those damages.
A part of the case then is wrapped up, and the farmers did get some compensation. However, it's not done yet.
Yeah, they will get compensation, but we don't know the extent to that level yet. But what we do know is that in the compensation, it will include damages to their property and crops.
And speaking of compensation, a farmer who maybe did not get compensated in a different case, discussing a bridge being fixed that then created his wheat crop to flood.
This was a state case down in Louisiana, the State Court of Appeals in Louisiana. And what you had was a farmer that was growing wheat, and that his field would normally drain into a ditch that flowed alongside a road and went under a bridge down at the road. And that ditch that flowed under the bridge became filled with silt over time and then debris. And this was a state bridge, a state highway and bridge, so the state was responsible for maintaining that. And there were several days of heavy rains. The farmer notified the State Department of Transportation that there was a blockage, and he needed that to be cleared so his field would drain and his crops wouldn't flood. We made a request. He made a couple more requests on consecutive days. The state eventually got there, but 2 weeks after his first request, and after 6 days, his crops were lost. He lost the entire wheat field, and then the state comes and fixes the obstruction. So he sued, saying that was negligence on the part of the state. He should be compensated for his crop loss. And the court said, no, the standard of review here on the state government agency, in accordance with state law in Louisiana, and this is going to be pretty much the outcome everywhere else, was whether the state acted within a reasonable time. And the court determined that based on the circumstances, they did. Their equipment was committed elsewhere, their workers were committed elsewhere, and they got to the project as soon as they could. Unfortunately for the farmer, it was too late.
So how does this court case really compare to the one we've just talked about?
Well, the one we just talked about was a takings case, and that invoked the constitutional requirement to pay compensation. This state case was couched as a negligence case, that the state basically acted negligently, causing him damages. And so when you have a negligence case, there are four elements to recovery. You have to have a duty to act, a breach of that duty. The breach causes damages. And obviously he had damages. He had to establish that there was a duty that the state had to clear that obstruction. They breached the duty, which then caused his damages. And the court said that they didn't breach their duty. They acted in a reasonable manner. So two different types of cases, two different legal analysis. One was a constitutional takings case. One was a negligence-based case.
So for this wheat farmer, hopefully his crop insurance is doing something for him?
Yeah, hopefully he gets a recovery through crop insurance that can make him whole. Otherwise, it's a really bad result for him.
One more case that we wanted to talk about today was the importance of a buy-sell agreement, especially for estate planning.
Buy-sell agreements, I think, are probably almost as important as a properly drafted will or a trust is for many farmers and ranchers, particularly those that want to keep the farming or ranching operation in the family from one generation to the next. It's a good intergenerational transitional device to use. Now, with that much said, of course, the agreement has to be operational, and the way that we make that operational often is by the use of life insurance. What we have here is a recent case coming out of Missouri. It's a decision on appeal by the U.S. Court of Appeals for the Eighth Circuit. And the issue in the case was when the family corporation that in this instance was owned by two brothers, owns the life insurance policy and the proceeds are paid to the corporation to be used to redeem a deceased shareholder's stock. The question is whether the value of that life insurance, the proceeds, add to the stock value of the corporation, add to the base value of the corporation for purposes of estate tax. And the two prior cases on this that we've had from the Ninth Circuit and from the 11th Circuit, there's also a prominent tax court case out there, said no, that stock is not really in the corporate value because it's going to be immediately utilized to redeem a deceased shareholder's stock, and so therefore we don't count that. So it doesn't add to any potential estate tax. It doesn't add to the value of the corporation. Here we've got the Eighth Circuit going the other direction, and they're saying, yes, it is included in the stock base, and so this was about $3.5 million of additional value that was in the corporation, resulting in over $1 million of additional federal estate tax that had to be paid when the deceased shareholder died because they said that added to corporate value, it enhanced his stock value that was included in his estate. So now we've got a split of authority between the courts. But the problem we had in this case was that the brothers that owned a small business, privately, closely held business, did not follow the buy-sell agreement during life. They didn't do annual corporate valuations. They didn't do other things that the buy-sell agreement required. And so the court found it pretty easy to say, well, you ignored it during life. We're going to ignore it as a valid value-restricting agreement at death. And the result was they had to pay more than $1 million in additional federal estate tax.
I think that really hits home a point that you've talked a lot about is the importance of knowing what everything's going to do when it comes to the estate planning.
Right. Drafting of these agreements, absolutely critical, and then following what the agreement requires you to do during life is also absolutely critical. Those 2 points are important for farmers and ranchers to understand and remember when they have these type of documents to aid them in transition of their business.
That was K-State and Washburn law professor Roger McEowen, and his blog article will be linked in today's show notes, which you can find on agtoday.net. We're cutting to a short break now, but we'll be back with more ahead on Agriculture Today. You're tuned in to Agriculture Today, and usually on Tuesday we have a Farm Bill update on the history, but since we don't have a show on Tuesday, we get our Farm Bill information today on Wednesday. And to do it, as always, we're joined with Extension Ag Policy Specialist and Flinchbaugh Agriculture Policy Chair, Jenny Ifft. Jenny, thanks for joining us again.
Great to be here.
And so, talking now maybe not about the best part of ag history here, the farm financial crisis.
So, you could think of the farm financial crisis starting at the end of 1979. In December, the Soviet Union invaded Afghanistan, and a grain embargo was put in place. In the short term, drastically decreased the price of agricultural commodities. So, farmers had grain in storage. Its value dropped overnight. Now, prices did go back up, and there were offset measures that took place, so the impact wasn't as big as the immediate impact. But this is when you look back to the farm crisis, this is what people remember, and we're still seeing the impacts of that today.
And another thing you mentioned with the farm financial crisis is one of the things that came was higher interest rates.
Right. So again, a lot of people look back on the Soviet invasion, but there was really 3 things that caused the farm financial crisis. First of all, you had high inflation throughout the 70s, and by the early 80s, the Federal Reserve Bank was going to address and bring down that inflation, and a part of this was through interest rates. So you had interest rates going up. During the 80s, a lot of farm loans would easily have 15 to 20% interest rates. So, interest rates feel pretty high right now, but they were, double or worse back then. And on top of that, a sizable number of farmers had built up a large share of debt in the 1970s. So one statistic I have, by 1980, 25% of farms in Iowa were highly leveraged. So by the early 80s, first of all, the agriculture was integrated into global markets. We were exporting a lot. And in this position where farms were very vulnerable to macroeconomic changes.
And Jenny, something you mentioned beforehand was that the collateral and the amount that the loan were not equaling up.
So by 1985, the Farm Credit System, Farm Credit System lenders are jointly the largest lender to U.S. agriculture, but the Farm Credit System had $6 billion in loans where the value of the collateral that secured those loans was less. So it was a financial crisis.
So, Jenny, you mentioned 1985. However, taking a quick step back to 1981 and that Farm Bill.
So Ronald Reagan was president in 1981. Similar to a lot of other presidents, his general philosophy was, let's get the government out of agriculture, let's let the market set prices. So a lot of fierce debate, like other farm bills, for that 1981 Farm Bill. And ultimately, there ended up being not a lot of changes. So we talked about the government cheese last time. So dairy prices were no longer linked to parity. They set more market-based support prices in legislation. So there were a few reforms, but really not a lot of changes in that Farm Bill. And you also didn't see a strong response to the emerging farm crisis. That came later in the 1985 Farm Bill.
And so moving to the 1985 Farm Bill, something that happened kind of before then was the largest loss by the U.S. financial institution.
The Farm Credit System reported a loss of $2.7 billion in 1985 and $1.9 billion in 1986. And that was the largest financial loss of any U.S. financial institution at the time, not just agriculture. So it was huge. And because of this, Congress did step in. There was legislation passed in 1985 and 1987. Now, some of this were structural reforms, changes to the farm credit system that are still in place today, but there was also financial assistance. You could call it a bailout. So money was provided to the farm credit system to help them get back onto firm financial footing. It took a while to repay, but that money that was given was actually paid back by 2005.
And so you mentioned 1981 didn't have a lot of changes, even though we were kind of entering a farm financial crisis. However, did we see changes in the 1985 Farm Bill?
Yes, there was definitely some big changes in the 1985 Farm Bill. A lot of them were in a sort of similar to what we'd seen in the past, where you had efforts to reduce supply. So the Conservation Reserve Program was started. This took land out of production and made environmentally sensitive land out of production, made payments for that. You had payments for reducing production. And one interesting change was there was this acreage allotment. So you could get, payments for only producing a certain amount of a crop. And in 85, the idea of base acres was introduced and put in place. So your acreage allotments, what you were allowed to produce and receive support for, was based on historic production. And we still use base acres today. And these are really important because what they do is they de-link these payments, these support payments, this income support from your current production decisions. The payments are based on your historic production decisions. So if you want to change your crop mix, or even if you want to fallow your land, if that's the best thing to do, based on environmental conditions, weather conditions, or the markets, a producer can do that and still be eligible for payment. So that's a very important policy change that happened.
And was this something that agricultural producers started to feel once that 1985 Farm Bill went into effect?
So there were a lot of direct payments that were authorized. So you had a couple years after 85 where direct government payments were about 30% of farm income. So there was a large government response to the crisis. Now, some would argue that it came too late, but it did come. And actually, Reagan, again, he wanted to reduce government involvement in agriculture, but you had this huge financial crisis, and the spending of his administration ended up being larger than any previous president.
And Jenny, what was kind of taking place locally for people?
Sort of to give you a sort of more of a flavor of what happened locally, you have reports of counties with 40 bankruptcies, 3 banks failing, but also a decline in school and church enrollment. So people were, leaving the farm, leaving rural areas, equipment dealerships were closing, retailers were closing. So, it was definitely felt at farms, especially for those farm families who had to sell or went bankrupt and had to leave, but more broadly throughout rural communities. And I think there's a lot of memories of this still today.
And talking about memories, kind of this legacy, you mentioned that people may have thought that the response to the farm financial crisis was not as fast as it should have been. And so have we seen changes in that with our recent issues we've had?
Definitely. I think, you saw a strong response in the late 90s when agricultural prices went down, a lot of it driven by the Asian financial crisis. You saw a pretty quick government response to that. If we look more recently, during the trade war, the Trump administration, during the COVID pandemic, there was a pretty rapid government response to those. So that's potentially a legacy of the farm crisis. You can also look at agricultural lending. The farm credit system today is very financially robust, even through the ups and downs of the past 2 decades. Agricultural lending in general is considered very conservative. And I think you still have a lot of lenders that remember sort of this enthusiasm in the 70s and how farms were allowed to build up debt based on the value of their collateral. Farmland values declined, and then you had this financial crisis. So that's still in the memory of financial regulators, but also some loan officers and bank managers. So agricultural lending is quite conservative. Now the question that we're asking now, is because the sort of conservative nature of agricultural lending, are some of those riskier loans held by non-banks, non-financial institutions. So yeah, those changes still reverberate today.
And is this something that you feel like we'll just continue to remember for many, many years moving forward, and will continue to affect how things are taking place in terms of agriculture banking?
I mean, I think there's always echoes of history, but the farm sector today looks a lot different than it did in the 1980s, and in 20 or 30 years, it'll look even more different. So I think institutions will continue to evolve, but I still think history has a lot of important lessons and will continue too, including the 80s farm crisis. The stress wasn't just in the farm credit system. It was also, felt by commercial and community banks. But one thing that also happened is the Farm Service Agency lending programs, used to be called the Farmers Home Administration, FHA. But their role in lending actually increased almost 20% of all loans during that period. So they are still today a lender of last resort. So their lending programs are targeted towards underserved borrowers or borrowers who can't get credit through traditional means. Well, that was happening to a lot of lenders during that period. So lending volume increase. There was a lot of problems with delinquencies or, farms that weren't able to repay. But ultimately, as the farm credit system recovered, as commercial banks recovered, they ended up taking on a larger loan share. So it was definitely a temporary role that was played by the Farm Service Agency during this period.
So just a little sneak peek to our next conversation about Farm Bill, maybe a little bit more positivity?
So we're going to talk about the 90s and specifically 1996, Freedom to Farm, the Farm Bill that's known as Freedom to Farm. And that was a major shift in farm policy in the U.S.
So stay tuned. Next week on Tuesday, we'll have a Farm Bill update talking about the Freedom to Farm, obviously more in depth. Jenny, thank you for joining us today.
Great to be here.
That was K-State Extension Ag Policy Specialist and Flinchball Agriculture Policy Chair, Jenny Ifft, with a little bit more information about the Farm Bill, talking about the 80s this time. We're cutting to a short break now, but we'll be back with more ahead on Agriculture Today. You're tuned back into Agriculture Today, and we conclude today's show with the Beef Cattle Institute's Ask the Experts.
Hi, welcome to Beef Cattle Institute's Ask the Experts, where our experts will answer your questions. Glad to have a couple great experts with me today, Dr. Bob Larson.
Hello, guys.
And Dr. Phillip Lancaster.
Hello, Brad.
On this show, we get an opportunity to answer questions from you, and if you have a question, you can send us an email at bci@ksu.edu. And when they answer, they get up to 10 points for their answers. So today's question is a great one and talks about, should I pull the bulls or remove the bulls from a breeding herd after a short breeding season of 80 days? I'm going to go with you first, Dr. Lancaster.
I'm going to say yes, that I think you should pull the bulls because I don't want my calving season to stretch out for a long time. I want those calves to be relatively similar age so that they're easier to manage through the production cycle, and I've got a more uniform group to sell at weaning. And then also for the bull's sake, so that he can get back into condition before winter comes.
Okay, absolutely. So starting out with 6 points, talked about the long-term effects on the bull, long-term effects on the herd, and thinking about marketing. Bob?
I don't fully disagree with what Phillip said, although one of the things, if I pull the bulls, first of all, it's usually quite inconvenient if I've got a good-sized pasture at all to gather a bull or gather the whole herd just to pull the bull out. And then I've got to decide where am I going to put him. I've got to have some facilities to put him in. And the other thing is, if there's some cows in that herd, and there probably are a few that are not pregnant yet, and I leave the bull in there, there's a very good likelihood that he can get them pregnant. Now, I do agree with Phillip. I like to have a confined calving season, but I can get that by doing a pregnancy check a little bit later and identify those cows that got bred late and sell them in a bred cow, sold to someone else where that she fits their system, is more valuable to me than an open cow in almost every situation. And so I would like to leave him out there, but do a preg check so that I can identify those late bred cows and they don't get to stay till calving.
Oh, I like that. So you're making a distinction between the breeding season and the calving season, and often we think of those two as the same, but they don't have to be if you use preg check for culling. Is that what you're saying?
That's exactly what I'm saying. I like a confined calving season, but I can have a longer breeding season.
Okay. Now, part of the listener question was, it said 80 days. So I'm going to ask you, and maybe breeding or calving for you, what is the right length of time that I should think about for that calving season?
I think some of that depends on the environment that you're in. If I'm in a good nutritional environment and my cows have really good grass coming into the spring, they should come back into estrus, and I should be able to get good rebreed up on them in probably about 60 days or so and not have to go as long. Now, if I'm in an environment where I don't want to put the feed resources into them, but I've got lower quality forage, and I may want a little longer breeding season so that I can get a better breed up on my cows.
So currently, Bob has 7 points and Phillip has 7 points.
All right, I'm going to say relatively short, and I'm going to I'm agreeing with Phillip. I'm going to aim for that 65 days or so, in that we know from some research that herds that year over year over year keep their breeding season short, their preg rate is actually better than those who allow it to get long. Now, if my breed up isn't where I want it to be, 92, 95%, then I'm probably going to leave my breeding season long for a little while and then slowly decrease it. But, it's a little bit counterintuitive. You'd think the longer breeding season, the better the breed up. Well, our research would say that herds that have a defined breeding season actually breed up better.
And why do you think that is?
I think it's because it kind of forces you to do a lot of things well. It forces you to watch that body condition going into the breeding season. It forces, I know that there's no late calving cows because they all calved, within that 60, 65-day calving season. And so I think a lot of positive things accumulate over years. So I think it's still a very good goal to have a 65-day-ish calving season. And I will accept that in certain situations I want to go longer than that, but my goal is still close to 65.
Well, and you're working on the assumption there that you get most of those calves early in that season, and then by the end it's tailing off. And I like the idea of keeping it to 60, 65 days. So you had two great perspectives on pull the bulls or don't pull the bulls, but I would say do what matches your operation, and then somewhere between that 65 to 80 day calving season. Thanks for joining us. Bob finished up with 9 and Phillip with 8.
That was BCI's Brad White, Bob Larson, and Phillip Lancaster. That's all we have for you today on Agriculture Today, but we'll be back with you tomorrow.